Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, for those of you who've been watching the channel for a while, you know we've been doing this ongoing series of videos about solvent traps. And really, one of the big problems with this entire issue related to solvent traps is the ATF and their continuous changing of interpretations of the law to come up with more and more creative interpretations about how a piece of metal now suddenly constitutes a suppressor. But that's not the only example of this, what's going on here, and some of the other things that we need to be aware of. So let's spend a few minutes today talking about, is the ATF coming after your trigger too? Okay, before we get rolling, you guys know the drill. If you like this video, go ahead and click that like button down below. If you want to stay up to date on issues related to your Second Amendment right, go ahead and click the subscribe button down below. Click the little bell logo if you want to be notified when we post new videos. And most importantly, let's keep the comments and discussions coming so we can make sure we get our videos out to more lawful and responsible gun owners like yourself. Okay, so the issue that we're going to be talking about today is forced reset triggers, wide open triggers, the rare breed trigger. Now, for those of you who've been watching this channel for a while, you know we've already done a couple of videos about the forced reset or rare breed trigger and how it fits within the interpretation of Washington law, specifically the machine gun definition and found in RCW 9.41.010. Well, many of you may have purchased some of these wide open triggers, forced reset triggers. I have not heard the term binary trigger be used yet, and we have done a video on binary trigger, but the way the ATF continues to creatively interpret laws, it would not surprise me if this was the next thing. But according to an email, an internal email amongst the ATF, which was discovered and basically disseminated by the Firearms Policy Coalition. And now, for those of you who don't know about the Firearms Policy Coalition, they do some fantastic work protecting our Second Amendment rights. And candidly, their channel, Armed Scholar, right here on YouTube, is a great channel if you want to track what's going on with some of the big federal litigation related to your Second Amendment rights. But the Firearms Policy Coalition got their hands on this email. It was an inter-office email amongst ATF agents. But what it clearly demonstrates, and we'll share the actual language with the email with you in a second here, but what it clearly demonstrates is that the ATF is going to step up a significant enforcement effort on those who have purchased or are selling these rare breed triggers. Now, take a look at the very first paragraph of this email, which reads, "Good afternoon. Attached are the Cease and Desist letters and the FATD Technical Bulletin referring to the rare breed trigger and wide open triggers, FRT Trigger. You will also find a C&D instructions prepared by CC's office. The C&D letters and the PC statements have been cleared by the OCC. Important, please let your respective DAD know if you plan to serve a C&D to any FFL within your AOR." And again, we're not going to go ahead and break down all the acronyms here, but what's going on here is that they got cease and desist orders that are being accompanied with probable cause affidavits, which are going to be served on FFLs, and the Department of Justice needs to be notified when they are doing it. That's the first paragraph of this email. Now, what else does it say? Well, it goes on to say, there are two versions of the cease and desist letter. One for the companies that manufacture and distribute FFLs, and one for the distributors, retailers, FFL and non-FFL. Please work with your division counsel to fill in the highlighted areas with the appropriate information. So they are already saying, hey, listen, we got two ways that we're going to do this. We're giving you two cease and desist letters so that you can tailor these to whoever you're serving them on. Then the email goes on to say, as discussed, please be prepared to take possession of any documents and FRTs the manufacturer, distributor, retailer offers to the surrender. The manufacturer, distributor, retailer may choose to abandon the items, in which case ask them to complete a consent to forfeiture of property and waiver notice, or what's called an ATF Form 3400.1. If the manufacturer seller refuses to abandon the items, please take custody of the items and seize them for forfeiture so that they can be properly noticed. So, They're giving you options here. You can voluntarily surrender them and fill out a form, or they will just seize them. Great choices. And then finally, the email tells us, additionally, FMS will be collecting the number of FRTs recovered and the number of defendants found in possession of these devices. This initial request is for the time frame of October 1st, 2022 to present. Please have this information to me by COB, close of business, Monday, January 26, 2022. Moving forward, we will request to have the information by the last Friday of every month. I will route reminder requirements through DOOs with a CC to you. So, if this is an inter-office memorandum that's kicking around with the ATF, there is a significant enforcement effort in which they are going to be raiding FFLs, and they are going to be getting sales records, and they're going to be getting receipts, and they're going to go to Rare Breed, and they're going to get all of the shipping receipts and like that. And so you very well may be contacted by the ATF. So, God forbid the ATF shows up at your door. Let's give you some general advice about what to do. Now, again, I'm going to put a disclaimer here. I am not forming a attorney-client relationship with anyone who's viewing this video, but I'm going to give you some very general advice about what to do. What to do if the ATF contacts you. Number one, do not speak with them. Do not speak with them until you've had a chance to speak to an attorney. I want you to practice saying this. It's not that I'm not willing to speak to you. It's that I'm not able to speak to you until I first had an opportunity to discuss this with my attorney. Let your attorney decide whether or not you should have any further conversations with the ATF. Number two, don't speak to anyone else about this. You know, we have very few privileges. And other than spousal privileges, attorney-client privileges, privileges with your priest and doctor, you start talking to your friends, your cousins, your brother-in-law, your neighbors, your kids about any of this, that is not privileged communication. So don't talk to anybody other than your attorney about this. Number three, if they come to you and they want to search your residence or be invited in, they are asking for consent because they do not have a warrant. So, do you have to allow them into your home? No, you do not. Do you have to consent to a search? No, you do not. If they are asking you for permission, it's because that's the only method by which they can do that. Now, am I saying under any circumstance don't allow them in? Under no circumstance should you allow them to search? Well, that's an individual judgment call for you to make. But let's remember that they're not there to assist you. Now, if you are contacted by ATF or law enforcement and property is seized, what do you need to do? Number one, if seizure is going to occur, or if you're being told that seizure is going to occur, if at all possible, do it in the presence of legal counsel so that they can document it and be a witness to all of this and make sure that all of this goes according to plan. Number two, do not volunteer any other information about any of the items seized. Where you got them, what you used them for, who gave it to you, whatever. It does not matter. Do not give that information up to anybody other than your attorney. Number three, if you can do this, photograph all the property which is being seized in the condition at the time it is being seized, okay? And then finally, forms. Okay, now the ATF could present you with a couple of different forms. There is a form, a 3400.23, which is a receipt for property ticket, okay? And that basically is a form that says, hey, we took property from you. Here's a receipt acknowledging that. Can you sign that? Yes, you can. You should sign that, and you most definitely... Let me repeat this. You most definitely should get a copy of that. Now, there's also a form 3400.1, which could also be presented to you. Now, that form is called Consent to Forfeiture or Destruction and Waiver of Notice. Basically, what you're doing, are you admitting guilt? You're not necessarily admitting guilt, but you are saying, yeah, go ahead, take the property, and if you want to destroy it, knock yourself out because I don't need to have any notice. And no, under no circumstances should the 3400.1 consent to forfeiture form, that should not be signed by you. Finally, if you've been contacted by ATF or local law enforcement and property has been seized, you need to immediately document, as soon as they are done with you, write down everything that happened in an exact timeline and immediately contact counsel. Listen, you may have more questions about what's going to happen with these force reset triggers and the ATF or anything related to your Second Amendment rights. And if you do, don't ever hesitate to contact us at WashingtonGunLaw.com. Or, of course, you can call us directly at 425-765-0487. Now remember, Part of being the lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.